Bobby Slade is not on trial here.
Why isn't he? You knew, you hushed it up.
You are trying to mislead this jury, Teddy.
That is not true.
is
and
unethical.
you know it.
I will see you both in chambers.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti. I'm here to discuss the Idaho 4 case. Well, we've got the rulings in on several of the motions. One of them is his affirmation of all of his oral rulings that he made in court, and we're going to go through those individually, and then we'll go through some of the other orders that have come through. And from everything that I see, except for one, I don't see anything really negative towards the defense, but we'll go through them and let you decide. Let's just get right into it. Okay, so here's the judge's order memorializing his oral rulings on the motions in limine. And some of these are kind of weird because he didn't really rule orally, but and some of them are about as clear as mud, but we're going to go through them. And it says, introduction. Before the court are several motions in limine filed by both the defendant and the state. Oral arguments on motions was held April 9, 2025. On several motions, the court rendered oral rulings from the bench. This order serves to memorialize those oral rulings together with the findings the court made during the hearing. And when we get into the standards, it says all relevant evidence is admissible except otherwise provided by these rules or by other rules applicable in the court of this state. Basically what I read to you in a video yesterday. Rules of evidence 401, 402, and 403. So when we get down here to the analysis, we're going to start with number one, and that was the defendant's motion in limine regarding inflammatory evidence. I didn't really touch on this one that hard because it was very generic the way that the defense was asking for this. Defendant moves under IRE 403 to prevent the state from introducing testimony and evidence that is exceptionally inflammatory, arguing it is irrelevant and or unfairly prejudicial. The court finds this motion is premature. So basically, he's going to rule in favor of a rule against the defense's motion, but he's doing it in a way where he's saying this motion is premature because they're not really identifying anything specific. At this point, defendant has not identified what specific evidence he wants kept out or otherwise defined exceptionally inflammatory. Issuing an order as requested by defendant would lack any substance. The court finds this unnecessary and therefore denies this motion. However, so this is how it's clear as mud. This was particularly horrific unaliving, and there will be exceptionally graphic depictions of the victims and crime scene. Prior to seeking the admission of this evidence, the state is required to provide copies to defendant. If defendant believes the evidence is cumulative, unnecessary, or otherwise prejudicial, he can seek to take the matter up outside the presence of the jury. So while he denies the motion, he leaves the door open for each specific piece of evidence to be argued by the defense outside the presence of the jury before it's admissible. So in a way, this is a yes and a no. So that one is, even though he denies the motion, he left the door open. Number two, defendant's number three motion in limine, the use of the term unaliving. Defendant seeks to prohibit the use of the words unaliving, unaliving-er, and unaliving-a-did. Unaliving weapon and similar forms of the word unaliving as applied by the defendant. The state acknowledges it would be improper to refer to defendant as the unaliver, other than stating what the allegations are, and has no plans to do so or otherwise elicit similar testimony from its witnesses. Thus, the motion is denied as unnecessary. So, while he's denying the motion, once again, he's acknowledging the state says it won't do it. So if the state tries to do it at trial, all they have to do is object, and the judge should sustain their objection. So while that one is actually a denial of the motion, it is a denial with instructions. And I do have to change that because I had it down as actually that the judge agreed to that one, but that one is denied. All right, number 4, motion in limine, use of the term psychopath or sociopath. Defendant moves to exclude any reference to the term psychopath or sociopath at trial, arguing it is unfairly prejudicial under Rules of Evidence 403 and improper opinion testimony under 702. To make a long story short, the motion is granted. They can't do that, so we already knew that. All right, now state's motion in limine, improper death penalty comments. The state moves under Rules of Evidence 401 and 403 to preclude defense counsel from making what it calls improper comments about the death penalty. Specifically, the state is attempting to kill defendant, which defense counsel has stated in past hearings. Defendant stipulates to using phrases that comport with existing language in statute and jury instruction. As defense counsel recognizes, any such statements would be argumentative and improper. The court trusts defense counsel will comport themselves accordingly. The motion is denied as unnecessary. So we were right on that, but again, he denies it with instruction. So if it happens during trial, prosecution can object and the judge will likely sustain the objection. So everything so far is pretty cut and dry. Okay, now we get to number 8, defendant's motion in limine for unnoticed 404B evidence. And remember, this is a 2-part motion. One is to exclude any further 404B evidence from being, brought in. And the second part was to exclude the 404B evidence that they tried to bring in with the traffic stop. So this is just on future 404B evidence. Defendant moves in limine to exclude any IRE 404B evidence that has not already been noticed by the state, which at this point is only defendant's pre-homicide traffic stops. By way of example of allegedly unnoticed 404B evidence, defendant notes that the state intends to present evidence of defendant's graduate paper regarding how to conduct crime scene investigations and his Amazon purchase records, both of which defendant contends are subject to IRE 404B. And then he goes in to explain how he disagrees with its 404B like he did at the hearing. And then he concludes with further, the court is unwilling at this point to preclude the state from filing a 404B notice in the future if it determines its evidence is encompassed by the rule. There are still 4 months until trial begins, well within the reasonably in advance of trial time frame required by the rule. The motion is therefore denied. So we knew that was coming. Next, we've got defendant's motion in limine number 10, defendant's motion in limine number 11, and the state's motion in limine regarding the investigative genetic genealogy. So the middleman testimony is already stipulated by both parties that it's unnecessary. But what's very interesting is the fact that they're both wanting IGG excluded, and the instructions that the judge is giving about this, which are unbelievable. Both parties moved to exclude evidence of law enforcement's investigative genetic genealogy testing in this case, but for entirely different reasons. Given the parties' agreement to not present any IGG evidence, those reasons need not be discussed given the bottom line agreement, and the court grants the motions. So the court's going to grant both motions, defense and prosecution, because they want the same thing. But look at this. The state has indicated it will present evidence through Detective Brent Payne, that defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutually agreeable narrative. about how the tip came about. So basically, I said, this is the most insane thing I've ever seen. The judge is instructing the prosecution and the defense to arrive at a mutually agreeable narrative about how the tip came about. He's essentially saying he's instructing the prosecution and the defense to come up with a mutually agreeable lie about how the tip came up. He said, all right, y'all don't want to bring it up? That's fine. Y'all get together and decide the lie, the narrative that you both want to use. So we need both of y'all to come up with the lie. The parties are also directed to jointly craft a jury instruction. To jointly craft a jury instruction. So jointly craft a lie for the jury instruction, advising the jurors not to concern themselves with the source or nature of the tip. So not only do you need to come up with a mutually agreeable lie, you need to come up with a strong enough mutually agreeable lie that we can draft a jury instruction to why the jury shouldn't concern themselves with the lie that y'all made up. What in the heck is this all about, and how is this even possible in this day and age? If the agreement cannot be reached, the parties are to submit to the court their proposed lies, or proposed narratives prior to trial, and the court will decide, how it will be presented. So if y'all can't reach an agreement, y'all both submit your lies, and then the court will decide, which lie we go with, or if we just make up something else entirely. This is our judicial system? Are you kidding me? No. What is going on with this IGG crap? All right, defendant's motion in limine number 13, conditions as aggravator. Now this goes towards the penalty phase, and what they're wanting to exclude the prosecution from doing is using the autism spectrum disorder diagnosis as an aggravator towards receiving the death penalty. Defendant moves to prevent the state from using defendant's diagnosis of autism spectrum disorder and the characteristics of his autism spectrum disorder as an aggravating factor at the penalty phase of the trial. And the motion is granted in part only. So they can use his symptoms, but they can't use his actual diagnosis as an aggravator. Real simple. All right, state's motion in limine regarding alternative perpetrator evidence, what we just discussed in detail yesterday. The state seeks an order prohibiting defendant from offering alternative perpetrator evidence without first making a showing that such evidence is relevant and admissible under 401 and 403. Notice they don't say 402 because 402 actually is the rules of Meister. These rules govern by the standard of admissibility for alternative perpetrator evidence, State versus Meister. And then they put a notation in here, mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403. In other words, they have to show a direct connection to the crime. Defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to defendant, this case is full of alternative perpetrators, and he intends to produce offers of proof as to alternative perpetrators. While defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. Laying foundation for the admission of the evidence will likely take a significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. To avoid undue delay at trial, defendant must present the offers of proof no later than May 14th, so the matter can be addressed at the pretrial conference. Court will reserve ruling on this motion. Actually, by reserving ruling on the motion, they ruled in favor of the defense because the prosecution wanted it eliminated altogether. So I guess the judge is going to try to push them for that May 14th. I bet we'll see some type of response from the defense. So to make a long story short, they are going to let the state bring in the Amazon click history. So that motion was denied, and I'm going to do a complete video on that, including some of the excerpts from the actual hearing itself, because that one is an interesting one. And the more they kind of let us know about it, the more it makes it interesting. But we'll save that for another time. But the judge ruled with the state. Now we've got the state's motion in limine regarding the AT&T timing advance records. The state moves in limine to prohibit the defense from making any references to the absence of AT&T timing advance records related to defendant's cell phone. So look at what the state is asking for. They don't want any references made to this AT&T timing advance. The state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by defendant that the record could have or should have been provided to the defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. In support, the state provides certificates of authenticity, AT&T, for each of the two warrants, stating that it did not provide timing advance records for phone number Kohberger's phone, because such records were, at that time, only available if requested within 7 days of the specified time frame. Defendant, relying largely on the affidavit of its expert, Cy Ray, is adamant that the state did receive the documents, which he argues are exculpatory, and is hiding them. Defendant points out he has a constitutional right to challenge evidence against him, and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. Applying these principles here, defendant will be allowed to voir dire Special Agent Balance outside the presence of the jury to ask whether he received defendant's timing advance records covering the early morning hours of November 13, 2022, and the months prior when defendant was believed to have been in the area of 1122 King Road. However, if, look at the judge don't know, so he's saying if Agent Balance denies having received the timing advance records, defendant may not explore the matter further, either in voir dire or before the jury. Given the absolute lack of any factual basis supporting his position that the state is hiding them, thus the state's motion is granted except as qualified regarding the very brief voir dire outside the presence of the jury. So while they're going to say the state's motion is granted, the state's motion is not granted, because the state asked for the defense from making any reference to the absence of AT&T timing advance records related to defendant's cell phone. That's not what the judge ruled. The judge ruled that they're going to get to hammer Agent Balance on it on the stand in voir dire, and they're in trouble. So while they put granted, I'm leaving that just like it was. He ruled against it. All right, state's motion in limine regarding the self-authentication of records, which they were not prepared for. Oh yeah, by the way, Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded and thus highly improper accusations against the state. Further, not once in his affidavit does he address AT&T's 7-day retention period, which fully explains why the state was unable to obtain relevant time and advance records for defendant. It actually doesn't, Judge, if you listen to the argument. But even though he's got this strong language against Cy Ray here, you'll see he has actually nice language in other parts of this related to Cy Ray. So even though he may act like he's upset with Cy Ray, he certainly is not excluding him as the defense's expert. So the self-authentication of records. The state moves in limine to permit the admissibility of approximately 60 exhibits pursuant to IRE 803. The state represents that it will obtain and submit certifications for the foregoing exhibits to render them self-authenticating. However, the state acknowledges that IRE 902 contains a notice requirement that has not been satisfied. The court's ruling on the motion is reserved, so he's not going to rule on this motion because the state was not prepared, and he could have excluded all of that. Now we've got the state's motion in limine regarding admissibility of demonstrative evidence, the Barbie dollhouse. And we've already put the way that he ruled, but we'll go ahead and read some of this. The state seeks permission to use a not-to-scale 3D model of 1122 King Road residence as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish the basic accuracy of the model and demonstration that it will be helpful to explaining the testimony of the presenting witnesses. Now, here's what's funny. The state contends the model will aid certain witnesses in describing their testimony. Was that the state's argument, or was that the judge giving the state the proper argument for him to rule on this? Let's take a look and see what really happened.
A not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly we can use diagrams and floor plans, which we did at the grand jury, but it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each floor, where the bedrooms are, how the first floors.
For it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located.
Now, did you see that happen in real time? Thompson begins his argument by stating it'd be nice to have a model for the jury to be able to look at and be able to visualize where everything was. And then the judge stops him and says, yeah, but the purpose of a demonstrative exhibit is so that the witnesses, it could be actually part of their testimony to describe things. And then Thompson, I'll give him some credit. He is really fast on his feet. He immediately responds with, yeah, that's exactly what we're getting at, Your Honor. The witnesses will be able to use this exhibit as part of their testimony. So the judge gave him the argument, mid-argument, and then Thompson just immediately adjusts his argument on the fly and makes it match what the judge said. So it wasn't Thompson's argument, it was the judge's. And that happened many more than one time during that hearing. Yeah, so that was not going to be Bill Thompson's argument, but the judge went ahead and told him how to argue it, and Thompson was sharp enough to take the judge's instructions and mold his argument to fit what the judge wanted real fast. So that was kind of shady. Defendant objects, arguing the state's drawing of the model and other related information was only recently disclosed in discovery in a file defendant describes as massive. Defendant claims the data and model cannot reasonably be evaluated by its expert in time. Defendant disputes that the model is relevant, and even if it was, claims it should be excluded due to the danger it might not be accurate. The homicides occurred in 2 bedrooms within the 3-story home with a complicated layout. The suspect's ability to enter the home, carrying out the stabbings, and exit the home consistent with DM's observations. You see, that is the key to their whole case. Consistent with DM's observations. Will be a central point of the trial. You can bet it will be, particularly given that defendant is challenging whether it could be accomplished by one person within the time frame alleged. While defendant's expert, Mr. Nodal, contends there is a risk the state's model could be misleading if it misrepresents the location of a wall or door or actual line of sight, those are simply concerns at this point. The state intends to lay foundation to establish that the 3D model fairly depicts the residence, and if it fails to do so, the model will not be allowed. Further, defendant is free to cross-examine the testifying witnesses and put on its own evidence, including experts. He may also use his own demonstrative exhibits if proper foundation is laid. However, the state is not going to be held to a standard of precise accuracy in this regard. It will only need to demonstrate accuracy to the point of avoiding deception, which is BS. Defendant, as soon as it's completed, no later than the pretrial conference. What were they saying here? Again, accuracy is not the standard. Mr. Nodal need only assure himself the model is not deceptive, and there is sufficient time to do this given the August trial date. To this end, the state is to make the model available to defendant as soon as it's completed, no later than the pretrial conference. Motion is granted. So they've got to give it to the defense no later than the pretrial conference, and then the defense can look at it and see if it's deceptive. All right, we got state's motion in limine around the alibi, one of the biggest ones in the case. And you know I did a video on this, and I'm loving this one. The state moves to preclude defendant from offering any evidence in support of an alibi other than from the defendant himself. The basis for the state's motion is defendant's failure to comply with the notice requiring governing alibi evidence. If requested by the state during discovery, a defendant intending to offer an alibi must file a notice listing the specific place or places at which defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. The court has the discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from a scene of the offense. An alibi is a defense based on the physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. At this point, defendant has only provided notice he was out driving in the early morning hours of November 13th throughout the area south of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, so he has no problem with Cy Ray testifying, you can see right here, to partially corroborate his alibi using CSLI data from defendant's cell phone. However, the alleged offense occurred between 4:07 and 4:20. At most, Mr. Ray can opine to where defendant's cell phone was up until 2:54, when it was apparently turned off. And approximately at 4:48 when it began reporting to the network. So why wouldn't you just say when it turned back on? See that his words there don't match. Defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules. So you should rule against it then, right, Judge? That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial. Bam. There are still 4 months until the trial begins. If defendant does unearth alibi evidence, it is his obligation to immediately make the state and court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if defendant does disclose alibi evidence. However, at this point, defendant has not provided an alibi, partial or otherwise. It doesn't matter because you just denied that motion, Judge. What does this say? This does not preclude defendant from presenting Mr. Ray's testimony at trial to rebut any contention by the state that defendant's vehicle was seen on surveillance camera driving to Moscow around the same time Mr. Ray contends he was south of Pullman. However, defendant may not refer to it as an alibi or partial alibi prior to closing. At that time, defendant is instructed to address the issue outside the presence of the jury for guidance on what language related to alibi of any sort may be used. So what did the judge just give them right here? Because the state is going to try to say it's Kohberger's car on all these different cameras, that opens the door for Cy Ray to be able to testify that Kohberger was at a different location than where those cameras showed that he was. So that means Cy Ray is able to address any time other than, I mean, anytime during the course of the night based on what the state produces in video. So he left the door wide open for Cy Ray to annihilate them throughout the entire night. And that right there is actually huge. And you can see that he is absolutely going to allow Cy Ray's testimony. Confusingly, defendant, oh, wait a minute. This is, okay. This is the second part to the 404B, state's notice prior traffic stop. So this is the actual traffic stop portion. The state moves under 404 for the admission of defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued a citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's OBV footage of the traffic stop as well as the citation, arguing it is relevant to proving defendant's identity, vehicle ownership and control, address, and phone number. So what's interesting is the video I did a week or so ago where I showed you that they had to prove Kohberger's identity in court because he stood silent and he didn't have a preliminary hearing. Well, the prosecution has actually used that against the defense as far as getting this evidence admitted. They're using this evidence they want admitted to actually identify Kohberger in the eyes of the court. So it kind of worked against the defense. But anyway, confusingly, defendant argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to identity. He also argues that it's unfairly prejudicial and may confuse the issues. Such evidence may, however, be admissible for other purposes, including to prove identity. So that kind of got him. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crimes. Indeed, the citation and OBV footage up to the point that defendant provides his phone number served to identify defendant by name, physical appearance, phone number, and address. The evidence also establishes defendant as the registered owner and driver of the vehicle, the make and model of which was thought to be used by the unaliver. Further, the evidence places defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All of these factors played a role in the investigation of the crime. While defendant cites to case law discussing identity under IRE 404 as requiring strong similarities between the bad act and the charged crime, this is in the context of establishing identity through a signature quality or modus operandi. Upon weighing the IRE 403 factors, the only portion of the video footage the court finds troubling is when defendant inquires why the officer needs his phone number. This inquiry could be perceived by jurors to be insolent. Given its lack of relevance and potential prejudice, the jury shall be redacted. So they're going to redact when Kohberger says, what do you need my phone number for? Other than this redaction, there's no basis for further exclusion. Defendant also contends it's unfairly prejudicial because the footage provides a clear shot of defendant's vehicle, which may lead the jury to believe it is the suspect vehicle captured on surveillance videos at and near the crime scene on November 13th. However, this is precisely what makes the evidence probative. It links defendant to the crime scene. It does not link the defendant to the crime scene. While this may be damaging to his defense, it is not unfairly prejudicial when balanced against its strong evidence. Thus, the motion is granted with noted redactions. It does not link the defendant to the crime scene when where he was pulled over was, a half a mile from the crime scene on the main road in Moscow. So that was some BS. And then you see in the notes here, noting the demanding standard required to establish identity through modus operandi evidence, Wright and Miller advises that judges to distinguish between modus operandi exception for proving identity under 404 and other methods of proving identity so they don't impose the strict standards of proof on the other methods of proving identity. Anyway, those are our outcomes. We already knew every one of these. I think one of them actually changed, but it didn't really, and I'm going to show you that in the end. But right now we're going to go to the other rulings that came through that weren't on this. Okay, on these, I'm not going to go through and break them down. We're just going to get the rulings. Like this first one is the judge's order on the state's motion in limine regarding neuropsychological and psychiatric evidence. And what this was the state seeks to prohibit the defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations. So this is on the autism spectrum disorder, OCD, and the DSD diagnosis. And the judge has given a double ruling. All right, so he's granted the prosecution's motion, but then he's reserved judgment in part. So he granted it, but he reserved his judgment so he can change that at a future date. And again, this is regarding the penalty phase if Kohberger was found guilty, so not going to spend a lot of time on it. Next, we have the motion in limine regarding eyewitness identification by bushy eyebrows. And remember, all the defendant wanted to exclude was DM's testimony regarding her identification of bushy eyebrows, and then the fact that the state can bring that up during the trial. This was kind of a shot in the dark to get this one. So I don't think it's anybody's, to anybody's surprise that based on the foregoing, defendant's motion in limine regarding witness identification by bushy eyebrows is denied. I will do a video breaking all of the new information that we got out of this down, but as of right now, he did deny that motion. Next is the double motion on Riley Nolan's expert testimony and the fact that the defense wanted them to exclude the use of the terms touch and contact DNA. While I will do a video breaking all this down for you, we're just going to go right to the results. And the results are two different rulings. He is going to grant defendant's motion that touch and contact does not need to be mentioned during the trial, so that's a win. But he denied the defense's motion to deny Riley Nolan's bogus expert testimony that she's going to give, and he's going to allow it. Now, this one is on make and model of suspect vehicle, and this is, again, was the defense trying to keep the prosecution from claiming that the vehicle was all one vehicle on all the different videos, and he did exactly basically what he said he was going to do in trial, even though he didn't issue a written order. We've already put this one in the loss category, but he has denied that motion, and he's denying it based on expert testimony. And I think once the defense destroys expert testimony, it'll have a big impact on the trial. So when we go back to our list of everything here, you'll notice over here in the color coding that I have a lot more than just red and green for prosecution and defense, because a lot of his rulings weren't actual definitive rulings. So we'll go through each one. Alternative suspect evidence, the actual result is a reserved ruling for a later time, but since the prosecution was trying to exclude it altogether, then that is a actual win for the defense. So I'm keeping that in the green column. He ruled in favor of the defense for the alibi. He ruled in favor of the prosecution for neuropsychological evidence for the penalty phase and for the model of the King Road house, the dollhouse. The IGG, he actually ruled in favor of the defense and the prosecution, but that's a weird one, so I'm leaving it green. Immediate family members in the courtroom, he still has not issued a ruling on that. His order that came out the other day, I didn't waste your time with it, because it's simply stating that the prosecution needs to jump through a lot of hoops before he makes his decision. So that one's still green, or still yellow, I mean. He has not ruled on the 911 call yet. He ruled in favor of the defense on improper death penalty comments. No decision on the text messages yet. He actually ruled in favor of the prosecution, but not really on the AT&T timing advance reports, because he's going to let the defense question special agent balance like they wanted to. So I'm leaving that one green. The prosecution was not prepared for the self-authenticating records, so nothing on that yet. Vague and undisclosed expert testimony, he's yet to rule on. Inflammatory evidence, he ruled on it, but he warned both parties. So that's a neither here nor there ruling. Use of the term murder, he technically ruled in favor of the prosecution, but he gave them strict instructions. So that one is kind of a here nor there ruling. Use of the term, psychopath and sociopath, he ruled for the defense. Riley Nolan, he granted the fact that they can't use touch and contact DNA, but he denied the defense wanting her expert testimony held out. So that's a one win, one loss. 404B evidence, Amazon click, he ruled in favor of the prosecution. Bushy eyebrows ruled in favor of the prosecution. They both stipulated on Middleman's testimony not being included. The IGG, again, he ruled in favor of both the defense and the prosecution, but there's still a stipulation on that, so I'm leaving those in yellow. Make and model of suspect vehicle, he ruled in favor of the prosecution, just like we had said. Conditions as aggravator, ruled in favor of the defense. Inconclusive data, he ruled in favor of the prosecution, but not really, because he left language in there open for the defense. In statistical analysis, he actually ruled in favor of the defense. So that's some of the so-called final rulings and what we're still waiting on. And we're still waiting on these two big ones down here. Motion to exclude the death penalty due to disclosure violations and motion to strike the death penalty due to autism spectrum disorder. So that is the scorecard as of right now. Anyway, I've got a lot to break down for y'all, and I still got a lot to bring to y'all, but I wanted to get this one out so everybody clearly understands where we're at in this thing as far as those rulings before, other people out there make bad determinations and mess everybody up, because I know a lot of y'all follow this thing really close like I do. So I got a lot more to bring to you, but I wanted to give you that update. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti is out.